Your Honor, it's our position that we did not agree to try the Blakely issue along with the jury trial. Neither did our client. If Mr. The prosecution thinks that we did, we didn't, and I don't think there's any record of us ever doing that. In order to do that, we would have to first get permission of our client. What I understood was that if we would lose the jury trial, after the jury trial, we would have a bifurcated trial with the court and let the court decide the Blakely issues. I would never agree to combine both of them. That was my understanding, and I believe it was Mr. Rangs and our client.
Your Honor, we absolutely did discuss this in chambers with counsel. We did talk about leaving the determination of the Blakely issues to the court rather than the jury. Counsel indicated that their client would agree to that. Not a huge, real surprise to anybody that does this. And then we talked about still having a unitary trial, not a bifurcated trial. And it was agreed to by everybody in the room. Now, Ms. Potter, of course, was not in the room at that time, but her attorneys represented at that time that they would not be requesting a bifurcated trial, that we were going to have a unitary trial. And I'm a little bit concerned that counsel is now saying on the record, absolutely, we did not agree to that, because we did agree to it. It was discussed and agreed to.
There are two Blakely issues that the state has submitted, and the two Blakely issues are that defendant's conduct caused a greater than normal danger to the safety of other people as she fired into a motor vehicle in which a passenger was present and two other officers were in close proximity while the vehicle was operational on a busy public street. After defendant fired, the vehicle traveled down the street and struck an unoccupied vehicle heading in the opposite direction. That's the first alleged Blakely factor. The second one is that defendant abused her position of authority as she was a licensed police officer in full uniform who had seized Mr. Wright. And I'm sure that your attorneys have explained to you what Blakely is all about, but those issues would not be an issue at all if you were found not guilty of either charge. If you were found guilty of one or two of the charges, your attorneys have indicated that they want me to decide whether these aggravating factors exist. The aggravating factors generally would allow me to impose a more severe sentence. Now, you have the right to have a jury decide these the existence of these aggravating factors. You have the right to call witnesses. You have the right to cross-examine any witnesses that the state would call. And I suppose you'd have the right to testify, too, if you wanted to, on those issues. You'd be represented by counsel. And the jury would have to find beyond a reasonable doubt that these factors existed. And the burden would be on the state. Is it your wish to give up your right to a jury trial on whether or not the two Blakely factors exist in the event of a guilty verdict?
Yes, Your Honor.